All right, if you are gearing up for the Queensland bar exams, you know that civil procedure can absolutely be the difference between a pass and a fail. So today, we're diving deep into one of the most powerful strategic tools you'll find in the UCPR, Rule 224. Honestly, getting this right isn't just about memorizing a rule, it's about learning how to take control of the entire flow of a case. We've all seen it, right? You're faced with this absolute mountain of documents. It threatens to just cripple your client with costs and totally derail your strategy before you even get started. Standard disclosure can be a real beast, and a lot of the time it's completely out of proportion to what's actually at stake in the case. So the question is, how do you wrestle back control? So here's our game plan. We're going to start with why we even need to escape standard disclosure. Then we'll get into the Rule 224 toolkit itself. After that, we'll look at two of the biggest battlegrounds, confidentiality and surveillance evidence. And we'll wrap it all up with a super simple checklist that'll help you absolutely nail this in an exam. Okay, Section 1, Disclosure's Great Escape. First up, why do we need an escape route at all? Well, the default position under the UCPR can be incredibly broad, and let's be honest, incredibly expensive. That's why getting relief isn't just a nice-to-have, it's often a complete necessity. And that relief valve, that escape hatch, is Rule 224. This is the court's power to step in and say, okay, that's enough. It's the key mechanism a judge can use to relieve a party from their duty of disclosure, making sure the whole process stays just, efficient, and, importantly, proportionate to the real issues in dispute. Right, Section 2, the Rule 224 toolkit. Now, pay attention here, because this is the core stuff you need to have down cold for your exams. Everything starts right here with Rule 224, Subrule 1. Burn that number into your brain, 2241. It's beautiful in its simplicity, but it's also incredibly powerful. It gives the court this really wide discretion to either limit disclosure completely or, what's more common, limit it to a specified extent. This is your foundational power, the source of it all. So how do you actually convince a court to use that power? Well, Rule 224, Subrule 2 gives you the arguments. These are the 4 mandatory factors the court has to consider. You're going to argue the time, cost, and inconvenience under 224-2A. You'll argue the importance of the documents to the questions in the case under 224-2B. You'll talk about their probable effect on the outcome under 224-2C. And then there's the crucial catch-all, other relevant considerations under 224-2D. So what does this actually look like in practice? Well, first off, the Supreme Court practice direction actually encourages parties to agree, to consent, to orders limiting disclosure. And second, and this is so important, the authority of Stephan v. NRMA confirms that getting a Rule 22-4 order is basically a complete shield. It means you can't get hit with penalties for non-disclosure under Rule 225. Okay, Section 3, the confidentiality tightrope. This brings us to that crucial catch-all factor, Rule 224-2D, and probably its most common battleground, confidential documents. Now, here's a fundamental point you have to get right. The general rule coming out of Science Research Council versus Nasser is that just because a document is confidential, that doesn't mean you can hide it. Confidentiality alone is not a shield, but the implied undertaking, the rule that documents can only be used for that specific proceeding, that gives you a baseline of protection. And in some exceptional cases, as we see in Hearn v. Street, the court can go even further and make really specific protective orders. So the million-dollar question is, when do you get one of those exceptional orders? The test, and you need to know this, comes from secret aircraft. You have to show a real risk of misuse of that information, a risk that's so significant it actually outweighs the other party's need for full access to build their case. This quote right here is your golden ticket for arguing restricted disclosure in an exam. And you can see how this balancing act plays out in real life. In Mobil Oil, the court said, okay, access is limited to just the lawyers and experts. In Adani, it needs specific orders to protect sensitive commercial data. But then you look at integrated medical, and the court actually allowed access, deciding that the need for a fair trial outweighed the confidentiality risk. The big takeaway here, it's always going to turn on the specific facts of your case. Let's move to Section 4, the surveillance evidence gambit. This is the other huge argument you'll make under Rule 224-2D, trying to postpone disclosure. And it's a classic move, especially with surveillance evidence in personal injury claims. So, here's the exam question you are almost guaranteed to see in some form. You're the defendant. You have a damning surveillance video of the plaintiff. Say they're claiming a back injury, but you've got them on camera lifting something heavy. Can you keep that video up your sleeve until cross-examination to really test their credibility? Or do you have to hand it over beforehand? The leading case here is Koster v. Bathgate, and it sets up this exact conflict perfectly. On one hand, you have the whole policy of the UCPR, which is all about full and early disclosure to help cases settle and to avoid trial by ambush. But on the other hand, there's a really strong public interest in unmasking fraudulent claims. And sometimes, surprise is the most powerful tool you have for testing a plaintiff's credibility. Now, while the court in Koster v. Bathgate absolutely acknowledged this balancing act, it made the modern trend crystal clear. The whole philosophy of the UCPR is geared towards full and timely disclosure. So yes, you can still argue to postpone disclosure, but you have to know that you are swimming against a very, very strong tide. One last super crucial tip on this. If your exam problem involves photos or videos or any kind of recording, your application has to deal with two rules. You have to address Rule 224 for relief from the general duty, and you have to address Rule 393, which has its own specific disclosure rules for this type of evidence. Forgetting Rule 393 is such an easy way to lose marks, so don't do it. All right, Section 5, your exam checklist. Let's pull all of this together into a simple blueprint you can use to crush it. Here it is. It's a simple step-by-step process. First, you state the power under Rule 2241. Second, you argue the factors in 2242 A, B, and C. Third, you spot any other considerations under Subrule D. If it's about confidentiality, you pull out the secret aircraft real risk test. If it's about surveillance, you balance the competing interests from Koster v. Bathgate. And finally, you always check if there are other related rules in play, like Rule 393. That's your structure for a top-tier answer. So what's the big takeaway here? Rule 224 is so much more than just another procedural box to tick. When you really know how to use it, it becomes a powerful strategic tool. It lets you shape the litigation, protect your client, and focus the court's attention on what really matters. So the question for you isn't just, do you know the rule? It's, how are you going to use it?